Today's topic continues with developing and communicating the business continuity plan. I'd like to personally thank each of you for joining us. These are very challenging, stressful times, unprecedented. Most of us are extremely busy. And so to carve out some time to join us today is so appreciated. We believe it'll be valuable for us to visit today and have this conversation. I'm Bo Birch, and I'll be hosting and facilitating this segment. A couple of housekeeping items. I'd like to remind us about the chat box feature where you may send your questions and challenges to us throughout the entire event. We do look forward to those. So if you've got your questions, please don't wait. Continue to send those in now. Also, we have a dedicated email established. So forward your questions and suggestions to workingremotely@humancs.com. If you would like to get in contact with any of our speakers or me today, make sure you receive this email, and it's posted here at the beginning of our slide and at the end, workingremotely@humancs.com. Our next Zoom event will be next Thursday at the same time, 11:45 Eastern. Next week, we will feature our same guest speakers of today and continue to discuss the new employment and tax changes and laws, how to navigate and be more successful with the volume of change that's been coming out of Congress and the administration. Our guest speakers today are three attorneys from the Forrest firm. We are glad and thankful to partner with the Forrest firm through this series. The Forrest firm is a full-service law firm with offices all across North Carolina, and they have clients around the globe. Today, we have Mr. Brian Bernhardt, a tax attorney. Welcome, Brian. We have Mr. John Burns, a litigation and risk management attorney. We have Ms. Nicole Murphy, employment attorney. So, Brian, John, Nicole, please briefly give us a little thumbnail of yourselves.
Good morning, everybody. This is Brian Bernhardt. As Bo mentioned, I'm a lawyer with the Forrest firm. I work out of Charlotte mostly, but I travel all over North Carolina and other places as necessary. My practice focuses on tax law, specifically in two main areas. One, tax controversies litigations, where I litigate against the Internal Revenue Service and the Department of Justice, defending companies, nonprofit organizations, and their owners when they're in tax disputes. And I spend a lot of time working with nonprofit organizations. At the same time, when new tax legislation comes out, like has happened in the last few weeks, I learn about that, make sure my colleagues understand it, and try to help my clients and other folks understand it as well. It's a pleasure to be here. Thank you all for joining us this morning, and I really hope you get something out of this morning.
Thank you, Brian.
My name is John Burns. I'm also with the Forrest firm. It's great to be here. We appreciate the opportunity. I am a commercial litigation attorney, so my job is to handle disputes for clients and hopefully help them avoid getting into disputes, or if they get in one, helping them resolve it, short of litigation if necessary, but we will go to court as well for our clients. When events like this pop up and the law changes as fast as it has been changing in the last couple of weeks, I and a lot of my colleagues try to get as expert as we can in those new laws to help our clients understand them and avoid conflicts and disputes related to them. So I'm happy to be here doing a little bit of that today and look forward to speaking with you. And you may hear my dog Addie. She has noticed that the neighbor is in his yard. So pardon that dispute, that distraction.
Thank you, John. Nicole.
Good morning, everybody. My name is Nicole Murphy. I am in Charlotte with the Forrest firm as well. I am the employment practice group leader, and my practice focus is in employment matters and general corporate matters. I've worked with a lot of small to mid-sized companies for the last over 13 years, both foreign owned coming to the United States as well as local companies here. And I am licensed in North and South Carolina. So being in Charlotte, we have a lot of cross-border representation going on there. So, and Thank you for the opportunity, Bo, to join you all today. And I know we've got a lot to cover and a little bit of time to do it. And we'll do our best to be a great resource for you and your audience.
Thank you so much, Nicole, John, Brian. It is truly a privilege to have you with us and this much expertise to share with our audience. Today, we'll be discussing many of the new laws that specifically affect the employer-employee relationship due to the breadth and granularity of these new laws, and they are continuing to change. Today, we'll be discussing at a high level a couple of the new laws as they are on your screen. The Paycheck Protection Program, aka PPP, Paycheck Protection Program, say that 10 times fast. And number 2, the Families First Coronavirus Response Act, FFCRA, or also known as the Family First Act. So those are the 2 that we'll be highlighting and discussing. Next week, we will be continuing to drill into these, plus and adding 2 more we'll talk about to the end of the segment. So my first question is for John. John, would you please just summarize and give us a nutshell of what exactly is the Paycheck Protection Program?
Well, I appreciate that question, Bo. The Paycheck Protection Program is the first article of a over 900-page statute called the CARES Act, which is the Coronavirus Response Act. The Paycheck Protection Program provides $349 billion in loan assistance to small businesses and nonprofits, as well as solo operations and independent contractors. These loans are in addition to traditional SBA loans and some loans called the emergency disaster loans, which you may have heard of. They're designed to cover or to help small employers cover their payroll and basic operating expenses through June 30th of 2020. And the overall goal of this statute is that Congress decided, and I think probably prudently, that it is better to keep businesses operational and keep employees on payrolls and insured with their employer-based health insurance during a pandemic, rather than having everyone close and roll off onto unemployment. Loans under this provision can be partly or entirely forgiven as grants under certain circumstances, and they're actually fairly lenient. But we can talk about how that happens and what these loans cover as we go forward today.
Thank you, John. So then who particularly will qualify to borrow from the Paycheck Protection Plan, John?
It's set up for small businesses, and that is defined as anyone with any business concern with under 500 employees. Traditionally, Small Business Administration loans only apply to actual for-profit businesses. In this act, that has been expanded. So any of your listeners who run nonprofit organizations, which 501c3 or 501c19 Veteran Services entities are also qualified. And as I mentioned a moment ago, this has been expanded to include independent contractors and the self-employed. But for small businesses, which I assume most of our listeners are today, it is businesses of under 500 employees, or if the Department of Labor has established a different level for your particular industry than whatever the Department of Labor decides or the Small Business Administration decides. But it is designed to help you meet your ongoing payroll expenses and keep people on your employment rolls through June 30th. And you get, through June 30th, based upon the starting of the emergency declaration in February 15th of 2020. They're trying to get us through from March to the end of June. Hopefully we come out of that at the end of June and people are able to reemploy their folks.
Thank you, John. This question could be for Brian or any of you three. So for those who qualify, you gave us some parameters there. How much money could I borrow? You know, the liquidity has vanquished. Employers need to get their hands on some cash. So how much cash could I get my hands on to borrow?
I think that's a key question for most businesses and business owners that are trying to borrow money. How much can I get? The goal of these loans is to help cover 2.5 months of your average payroll. That's what they're trying to look for. The idea is that in 2.5 months, hopefully we'll be past this and we can move on as we did before. Reasonable people can wonder about that, but the goal is 2.5 months of payroll. So the way they figure out for most borrowers what your average payroll is for 2.5 months is they look at your total monthly payments, your total average monthly payments for payroll costs over the year prior to when you get your loan, and multiply that by 2.5. So if your average monthly payroll over the last year prior to getting the loan was $100,000, you're going to be able to get a loan for $250,000, and that theoretically covers 2.5 months. Payroll costs is possibly more than you might think. It's not just the actual compensation. There are what I'll call add-ons, but aren't really add-ons. As an employer, you know that these are really part of your true payroll costs. Healthcare, insurance premiums, if you're making IRA, 401k contributions, there's taxes that you're paying as well. There are a lot of credits that you're entitled to under this act, but subject to not taking advantage of that, those are going to be wrapped into the amount of payroll costs. You can also add to that 2.5 average any prior disaster loan relief that you received after January 31st of this year. So February 10th came, you got some disaster relief funds. You're still able to add the amount of that disaster relief money to the loan that you're getting under the Paycheck Protection Act. The goal would be that you'd refinance that loan with the money you're getting under the Paycheck Protection Program. And that's a benefit, as John will talk about a little later. I think there are some loan forgiveness provisions here. So if you refinance this disaster relief loan that you have to repay into a paycheck protection loan, then suddenly that loan may end up turning into something that you are able to have forgiven. There are a little different rules if you weren't in business last spring at the beginning of this 12-month period, and there are some different rules if you're a seasonal employee as well. But for the most part, it's going to be, as I indicated, 2.5 months times the monthly average payroll. The one catch at the end is that in no case is a loan allowed to be more than $10 million. So if your average monthly payroll times 2.5 is more than $10 million, you're going to be capped at $10 million.
Thank you, Brian. That is very helpful. It really is. And so, one of the things folks are wondering about would be in today's environment, we have full-time employees and part-time. We have independent contractors, 1099s. How do the 1099s fit into this situation?
The 1099s that are a little bit in two different ways under this statute. And one of the problems when you draft a 900-page statute in a week and a half is that everything doesn't always line up. But what essentially, for the purposes of counting whether or not you have 500 employees, only your employees count. Full-time, part-time, you do a head count of all your actual employees. 1099 independent contractors do not fit into that calculation. When you're talking about some of the costs that Brian was mentioning later on in the process, how much is forgiven, how much can I borrow? I think Brian will tell you that independent contractors and your expenses for those contractors may in fact be counted because it forms part of your broader payroll costs. But for the purposes of deciding whether or not you are under 500, it's only your employees, which is probably a good thing for most of you.
Mm-hmm. Great.
Sounds correct. For purposes of calculating your payroll costs, when you're trying to figure out how much of a loan you can get, the statute is not limited to just employees. It talks in terms of payroll costs and not even direct compensation. So your payroll costs are going to include money that you're paying to 1099 independent contractors. So you can include that in the amount of payroll costs for determining how much you can borrow. But as John mentioned, because the statute specifically refers to employees for the headcount provision, independent contractors would not count there.
Excellent. So one of the things I think the audience's ears have perked up to, I'm hearing loans and I'm hearing something that sounds like loan forgiveness. It sounds like a grant. So how does that program work with a little more clarity on how we can address this as employers.
Sure, Bo. This is the most, I think, exciting or interesting part of this statute, and it's not something I think that the federal government has ever tried before. But because they're trying to keep people employed and on payroll, and they don't want to impose too much of a burden on small businesses, they're advancing this money as a loan. But if you meet the parameters of the statute, then after June 30th, after the period has expired, and hopefully the emergency has eased a little bit, if you've used that loan proceeds to pay the payroll costs and the other costs set forth in the statute, you can go back 8 weeks and take that amount of money and say, I'd like to be forgiven for this amount of money. And so basically it looks at the 8 weeks after the origination of the loan. And if you use the loan proceeds to pay your payroll costs, to pay the interest on your mortgage, to pay your existing rent, those monies will be forgiven at the end of the period. For most of you, that will probably leave some balance because you're borrowing 2.5 months and your expenses for forgiveness are calculated at 8 weeks. The remainder of the loan is still treated as a loan, but there are lots of deferral procedures, lots of ways to make sure that payment is paid later. And it is a non-recourse loan. So while your entity may be responsible for paying that amount, that small remaining amount back, it's not something that they can come after you for personally if you're an investor, a partner, or a shareholder, so long as you use the money for the statutorily designated purposes. You're capped at the full amount of your loans. You can't be forgiven for more or granted more than you borrowed. But for most folks, you're going to be able to get forgiveness for somewhere between probably 70 and 100% of the amount of loan that you borrowed.
Mm-hmm.
Bo, the key to making sure that you can have as much of the loan forgiven as possible depends on whether or not your head count of employees and your payroll costs on June 30th are the same as they were on an earlier date. I forget the date off the top of my head. John probably knows it off the top of his head.
It's February 15th. What you're trying to do and what they're doing in the statute, you may have already laid people off after February 15th, which was when the emergency was declared. A lot of folks have had to cease operations due to stay-at-home orders or laid off some of their employees. What they'd like you to do and are allowing you to do is between February 15th and a date 30 days after the enactment of the statute, which is going to be April 26th. If you have laid people off during that period, if you put those people back on your payroll before June 30th, you can still qualify for the full amount of your forgiveness and turn it into a grant. If you've reduced your payroll or your head count by certain percentages under the statute, and you don't hire those people back by June 30th, then the amount of your forgiveness is going to be adjusted by a formula that's set forth in the statute. So it encourages you to bring your payroll back up to the pre-emergency amount by June 30th in order to qualify for the grant.
And you don't necessarily have to hire those same exact people back. You can hire other people back. They just want to make sure your head counts and your payroll costs are as close to identical as possible. So those people may have found another job. They may have moved out of the state. You can replace them with somebody else and it's still going to be okay.
Excellent. John, Brian, anything else as we move into the next segment of questions?
No, but I do think that, and folks are already taking advantage of the chat. If you've got any questions, put them in there and we'll try to cover those sort of near the end and direct you to some resources where you might be able to find some further answers.
Excellent job, John and Brian, of helping us today get a working knowledge, a better understanding of how we can navigate and actually take advantage of the government dollars. These are our tax dollars that we will be have access to through the Paycheck Protection Program. Thank you again. Let's move to our attorney, Nicole. Nicole, you are, I understand you're very, very busy these days with conversations regarding the Families First Act. And so if you could give us a summary of, in a nutshell, of the Families First Act. What is this? What is this act? What's it about?
Thank you, Bo. Thank you. And to echo John's point too about resources in the chat, and everything that we're talking about today, we have on our firm's blog, and we are constantly updating it. And I'll make these materials available to your audience as well. But we just want to make sure that everyone has access, because it's a lot in a short amount of time, I realize. So thanks, Bo. To your question, so the Families First Act is, the long name of it is the Families First Coronavirus Response Act. And what it is basically creating a new form of paid leave, because we're anticipating a lot of people are going to either get sick with this virus, people that they love are going to get sick with this virus and need help and care, or a lot of people who would normally take their children to daycare and school, all those facilities are closed, and that puts a new constraint on parents for you know, how they can manage their home life and their business life. So this is creating a new form of paid leave that is applicable. Usually when we've heard of leave, we know that normally small businesses don't have to offer that. And it's, you know, if you have, people know, we've heard of FMLA, you know, but that only applies to companies who have 50 or more employees. And even for those larger companies, FMLA, Family and Medical Leave Act, means that your job is protected when you step away from work because someone's pregnant or a medical emergency, but that's unpaid leave. Now we're creating a paid leave obligation, and we're putting it on businesses. Now everyone who, if you have one employee up to 499 employees, you are now subject to providing paid leave under the new Families First Act. So that's quite a shift from what we're used to. And the law just came into effect yesterday. So it is now live. And if you have between 1 and 499 employees, you are now subject to it. So we can talk about, there's some opportunities for some exemptions for small groups, but happy to go into that as you need to, Bo.
So Nicole, it sounds like from what you're saying that the government is trying to help employers remain whole, if you will, with monetary resources, and in order to help the employer keep their employees whole with protection. Is that correct?
Well, actually, no, the employers are expected to pay this cost up front. So the employers are now having an additional burden. In the past, they never had to provide paid leave. Now they do. So this is an extra cost. So this is why it's important for companies to get these payroll protection and get these loans, because this is a new cost that they are likely going to have to use that loan money to pay for. The back end of this, the carrot and the stick, so to speak, the government is making small businesses pay this for their employees. So it's definitely an employee benefit. The benefit, the carrot though, is that the businesses will be entitled to a tax credit for the money that they have to put out on the paid leave. And that's where people like Brian and other folks, your accountants, can help calculate that. That's probably a little more in the weeds we'll get into on future webinars, but that's the trade-off. Businesses, you must pay this leave now, and in exchange later, you can claim a tax credit.
Okay. And so as we move along, the governor issued a stay-at-home order, so that means my employees are now quarantined, entitled to receive paid sick leave. Is that accurate, or?
Jumping ahead a bit, sure, that's no, that's not accurate. So the stay-at-home order is not the same as quarantine under the Act. So I think it would be helpful if we can discuss, you know, what does the Act cover, so that way we can know that the stay-at-home order, like right now, I'm staying at home. Many of us are staying at home. And we are able to work remotely. Some people now are designated as essential businesses, and some of these folks are able to go on site and work. So what to quickly answer the question you raised, Bo, no, a stay-at-home order is not the same. Just because I'm sitting at home and I'm working remotely, I am not triggering the new paid sick leave portion because I'm not sick with COVID-19 and no one that I'm caring for is sick with COVID-19. So I did see someone asked a great question here in the chat. Do you anticipate the act lasting beyond the corona pandemic? The act goes, so it went into effect yesterday, April 1st. The Paid Leave Act, the Families First Act, will stay in effect until the end of this year, December 31st, 2020, that we know of for now. So from yesterday until the end of the year, it's in play. Yeah.
Wow, lots of information, but you guys are great at taking this complicated, ever-changing material and bringing it down to where we can understand it. So we do have a number of people that have sent some questions and some of their challenges in specifically. Let's go ahead and take those. I will allow you guys, I think you can see those questions from the chat.
There's one thing I'd like to add, Bo, if you don't mind, because I think people are going to want to know when does this happen and how does it affect me related to the Paycheck Protection Program. The SBA has already released the application form, a 4-page application. It's really not, it's not complicated for a government form, believe it or not. It's pretty straightforward. And then they've also released a list of recommended, and the Chamber of Commerce has also put out a very helpful thing that gives you a list of recommended materials you should supply to your lender. The application's open for small businesses tomorrow. For independent contractors and the self-employed, the application period opens end of next week. And you're going to apply to your small business lender. You're not going to apply to the SBA. It's all going to be administered by the lenders themselves. So if you have an existing relationship with a business lender, that's the person that you want to talk to about, you know, how do I send this application in? What do you need me to back it up? But I realized that we hadn't covered that in our initial discussion of the act. So keep in mind, it opens tomorrow. There's $350 billion out there. And unless they get another bill, that's the amount that's available. So the sooner you can do this, the better for you.
So John, it sounds like it's on a first come, first served basis.
Correct.
And following up on that, Bill, because of everything John said and your last comment about first come, first served basis, today would be a great day to reach out to your lender and ask them what's going on, what their processes are. They probably have a copy of the application as well and have had their lawyers looking at it. But each bank, each financial institution is going to have their own independent way of doing this. We've spoken to some bankers that are creating a separate online portal where you can send your application through. Different banks may do it different ways. So contact your lender as soon as you can because as John mentioned, first come, first serve, $350 billion sounds like a lot, but it'll go pretty quickly.
Yes, thank you, Brian. Appreciate that. Other questions?
There's a question on here about the relationship between the Paycheck Protection Program loans and what are called emergency economic injury disaster loans, and whether you can apply and receive both. I think Brian has done quite a bit of work in understanding the EIDL or emergency disaster loan, but the first part of the answer is that if you've already gotten an emergency disaster loan after January of 2020, that amount will be rolled into your loan under the Paycheck Protection Loan. So it's for payroll costs and any emergency loan you might have. But Brian can talk to you about how those emergency and disaster loans work.
Sure. So in general, these emergency injury disaster loans allow for loans of up to $2 million. There's a low interest rate, 2 3/4 for nonprofit organizations, 3 3/4 for for-profit organizations. There's a 4-year repayment period. And that's just a general existing program that's out there. What the CARES Act does is provide an emergency component to that. When you apply for your emergency injury disaster loan, you're going to get an advance of $10,000 within 3 days of making your application. So the application itself may take a week, 2 weeks, 2 months, who knows how long for it to be granted or denied by the government. In the meantime, within 3 days after applying, you're going to get $10,000. Here's the great thing about this. Even if your emergency injury disaster loan is rejected, you get to keep the $10,000. So it's essentially a free $10,000 grant for applying for an EIDL if you think you qualify for the emergency loan. You'll have to make some certifications at the end of the application that you honestly believe you qualify and that sort of thing. And you are applying to the government, so you're going to be signing under penalties of perjury. So it's not just $10,000 for everybody. You actually have to legitimately believe that you're entitled to that loan. But if you do and you apply, you'll get $10,000 and you'll repay it back if you get the loan. But if you don't, then you won't have to pay it back. The relationship of this to the Paycheck Protection loans is that when your Paycheck Protection loan is forgiven, if it is forgiven, the $10,000 grant is going to be subtracted out from the amount of the forgiven loan that you get from the Paycheck Protection. That way, there's no double dipping on that $10,000. So if you borrowed, say, $100,000 on a Paycheck Protection loan, and you're able to have $10,000 forgiven, but you also have received an emergency EIDL grant, then you're only going to be able to get $90,000 forgiven because you already got this $10,000 that you don't have to repay in the emergency process.
Great explanation of a very important topic, Brian, John. So one of the things too, some folks are thinking about, how is this 500 employee limit calculated?
For the purposes of the Paycheck Protection Program, I also see some questions about how this might apply to people with companies under 50 employees related to the Family Act, and Nicole will certainly address that. But for the purposes of counting how many employees you have, it is to, and whether you're at the 500 level or not, it is a strict head count of full-time and part-time employees. So if you're on the border, if you're in the high 400s and you're wondering which of your employees count and whether you can qualify for this loan, you need to count your part-time employees and your full-time employees averaged over the 12-month period prior to, I think, February 15th of 2020. So you would take your average monthly employment over that period, and if you're at 500 or more, you're a mid-sized business. If you're at 499 or below, you're a small business.
Mm-hmm. Excellent. Any final
I think there was some questions in the chat related to whether the provisions of the bill that you're talking about can be exempted for certain small businesses. Would you mind helping folks out with those?
John, are you referring to me or Nicole?
Nicole, it's related to the FFCRA and whether there's any safe harbor provision or appeals for employers of under 50 employees.
John, thanks for repeating that, because I was I was responding to that chat box at the same time. Yes, so we know now that the new paid leave laws apply to every employer that has between 1 and 499 employees. There is this, some people are calling it a safe harbor. It's an exemption. How can I get out from under this new obligation? If providing sick leave for all of my people would basically put me out of business and I can't comply. So for businesses with fewer than 50 employees, there is some brand new guidance that has come down from the Department of Labor yesterday as to I have to be able to show that if I comply with this new law, it will financially ruin me. So it doesn't automatically apply if I can say, okay, well, we're fewer than 50. I don't have to pay attention to this paid leave law. No, you will need to prepare some documentation and at least be able, if you are questioned on it later, you will need to be able to show why we can't comply because we are at such a small size, and if we pay this out, we won't exist anymore as a business. I've provided the link to that. I'll go back into this link because they've just now yesterday released a little bit more information on what does it mean to prove that I can't comply. We've just received this yesterday, so it's brand new.
Thank you, Nicole. Thank you, John and Brian. We may get one more, and we have 5 minutes, I think, left in the program.
So the last question that just came up is from Jackie A. There's a series of questions she had, all of which are good questions. I think all of which, except for this last one, we've answered. And the last question on the chat goes back to calculating the amount of the loan that you can get. And I'd mentioned that the amount of the loan is your average monthly payroll for 12 months prior to when you're getting the loan. My guess is that ultimately it'll be the 12 months prior to your application. Otherwise, those numbers are going to change during the process. Jackie's question here is, hey, can we use 2019 calendar year information instead of having to add in or shift to second, third, fourth quarter of 2019 and first quarter of 2020? And the answer, I believe, is going to be no. And the answer is no, because the statute is very explicit about the 12-month look-back period. There's not an exception for looking at 2019. There are some exceptions for businesses that did not exist during February through June of last year, and there are other exceptions for seasonal businesses, so that may impact you. But if you've been a long-term existing business, it's going to be this 12-month look-back period. You should be able to get, at a minimum, second, third, fourth quarter of 2019 information from your payroll provider if you're using a third-party company. For first quarter 2020, you may have to pull that information out of your own computer systems, or depending on how fast your payroll company is working, they may be able to provide that information to you in the next couple of days. But you're not going to be able to rely on simply last year's information for the loan.
Thank you for that, Brian. Thank you, Brian and John, Nicole. Excellent work today. Carving time out of your very busy schedule to be with us. And our goal to get some important information out to our businesses and our audience to help us through these unprecedented, challenging times. So thank you again. We'll go to the last slide to make sure folks have the next event is next Thursday, 11 a.m. Eastern. We thank Nicole, Brian, and John for rejoining us next week. We're going to talk more about the CARES Act, the Families First Act, of course, and then this large volume of chat questions that have come in. We'll be able to get those and print them, maybe sort those out and focus on what your needs are as our audience, as our customer, if you will. Remember, the email to use is workingremotely@humancs.com. And very thankful, if you look at the bottom of this slide, additional key resources. The Forrest Firm is continuing to offer guidance and tools on their website, and they are very happy for you to log on and access that information. I'm sure their phones still will allow you to call in and to get an appointment, or if you need a personal visit. It looks like Zoom. That's their personal visits today, right?
We're totally remote. Absolutely.
You're totally remote. Right. I'm making a motion that we change this social distancing to physical distancing. Isn't it really physical distancing? Because that's really not social distances at all. But I'm very happy you guys could join us. There is just a volume of what is this and what are the deadlines and how do I get liquidity in the hands of my business so I can pay my rent, my mortgage, my employees, and keep this business continuity going. So tying into the business continuity plan. Hope to see you all next Thursday at 11 a.m. Thank you so much for joining in. Thank you guys again for being great speakers and great for our session today.
Thank you for having us.
Thank you,
Thank
Bo.
you, guys.
Thank you, everyone,
Thank
for
you.
visiting.